Hello friends, my name is Sampa Karmkar Singh. I am assistant professor at the WBNUJS Kolkata. Today we are going to discuss one very interesting topic, that is Hindu marriage and divorce. Family is the foundation of every society, and marriage is frequently theorized as the foundation of the family. India is a country of multiple religions, and in the absence of uniform civil code, every religion follows whatever rules and customary practices are applicable to them solely based on their religion. In Hindu law, marriage is a sacrament, whereas in Muslim law, marriage is a contract. In Christian law, divorce continues to be stigmatized, and in Parsi law, registration of marriage is central to the ritual of marriage. So, in a nutshell, every religion has their own customary practices, their own customs, rules, and they have their different laws, and they are governed solely on the basis of their religion. Whatever religion they belong, the rules will be applicable accordingly related to their marriage and divorce. Let me refer here one very interesting case, that is TMA Pai Foundation versus State of Karnataka and others. In this case, Honorable Supreme Court of India has reiterated that the essence of secularism in India is recognition and preservation of the different types of people with diverse languages and different beliefs, and placing them together so as to form a whole united India. There are 8 types of marriages under the traditional Hindu marriage. First is Brahma marriage, second is Deva marriage, third is Arsha marriage, fourth is Prajapatiya marriage, fifth is Gandharv marriage, sixth is Ashura marriage, seventh is Rakshasa marriage, and the last and the eighth one is Peshach marriage. These are various kinds as per the traditional Hindu laws. Now, the governing legislation related to Hindu laws or Hindu marriages is the Hindu Marriage Act 1955, which is applicable only to Hindus, because you can see from the name itself of the enactment, it says Hindu Marriage Act, means it is applicable only to Hindus. Now, when we talk about Hindus, the first question will come that who are Hindus? So, let us first know about who Hindus are on whom this act is applicable. So this act applies to any person who is a Hindu by religion in any of its forms or developments, including a Veerashaiva, a Lingayat, or a follower of the Brahmo, Pratna, or Arya Samaj. To any person who is a Buddhist, Jain, or Sikh by religion, and to any other person domiciled in the territories to which this act extends who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any custom or uses as part of that law in respect of any of the matters dealt with herein if this act had not been passed. It further explains that the following persons are Hindus, Buddhists, Jain, or Sikh by religion, as the case may be. First is any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jain, or Sikh by religion. Second is any child, legitimate or illegitimate, one of whose parents is a Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as the member of the tribe, community, group, or family to which such parent belongs or belongs. And any person who is a convert or reconvert to the Hindu, Buddhist, Jain, or Sikh religion. Under the Hindu Marriage Act, the kinds of marriages are 3 types. First is valid marriage, which is dealt under Section 5 of the Hindu Marriage Act. Second is voidable marriage, which is dealt under Section 12 of the Hindu Marriage Act. And the third kind is void marriages, that is dealt in Section 11 of the Hindu Marriage Act. Now, let us start with the first kind of the marriage, that is valid marriage. It is provided under Section 5, which provides the conditions for a valid Hindu marriage. A marriage may be solemnized between any two Hindus if the following conditions are fulfilled. First, neither party has a spouse living at the time of the marriage. Second is, at the time of the marriage, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, or though capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children, or has been subject to recurrent attacks of insanity. Section 5 further provides the age related to the bride and bridegroom. Section 5, clause number 3, it provides the bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of the marriage. Though we know that in our country child marriages are also there, prevalent in the society, but child marriages are not allowed, or you can say that these are illegal kind of marriages. However, these marriages are not void or valid, but they are voidable at the option of the parties. Fourth is the parties are not within the degrees of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. So here you have to see that it talks about degrees of prohibited relationship, which we'll discuss in our further slide. And it also talks about custom and uses. So here you have to be very careful that if any such kind of situation comes where you have to see that whether first you have to check that whether the parties are falling under the degree of prohibited relationship or not. And second, the test would be that whether their custom or usage which governs them allows for such kind of marriages or not. So this will be based on the custom and usage of the parties. The last one is the parties are not sapindas of each other unless the custom or usage governing each of them permits of a marriage between the two. So here again in case of sapindas, you have to check the custom and usage governing the parties. Now let us start with the different age because we have seen that the Act provides the age 21 and 18 respectively. So when we talk about this different age of bride and bridegroom, this difference in age for husband and wife has no basis in law as spouses. Entering into a marriage are by all means equals and their partnership must also be of that between equals. Recently, a bill was presented before the parliament which was related to the age of marriage should be increased to 21 for both male and female. However, it has not been passed yet, so the age till date is 21 for the husband and 18 for the wife. Coming to the Special Marriage Act 1954, the Special Marriage Act also prescribes this 18 years and 21 years as the legal minimum age for women and men respectively. However, under Section 11 and 12 of this Act of 1955, the marriages where one or more parties do not meet the legal minimum age are neither void nor voidable and merely liable to pay fine, which is provided under the Hindu Marriage Act of 1955. Section 3 of the Prohibition of Child Marriage Act, which is also in short known as PCMA. This act also deems as a marriage where one or more parties are minor as voidable at the option of the minor. The laws on guardianship are clear that the husband will be the guardian of his wife, minor or major. The issue also becomes relevant if the husband of the minor girl himself is a minor, then what will be the status, right? So in these cases, whenever you see about the guardianship of the wife, it is the husband. Coming to the prohibited degrees now. The parties are not within the degrees of prohibited relationship unless their customary practices which governs each of them permits of such marriage between the two. It is provided under the definition clause that what comes under the degrees of prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other. Second is if one was the wife or husband of the lineal ascendant or descendant of the other. Third is if one was the wife of the brother or of the father's or mother's brother or of the grandfather's or grandmother's brother of the other, or if the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers or of two sisters. So these are the people who are falling under these relationships will be treated as falling under the degrees of prohibited relationship. But the interesting principle here is that if their custom and uses permit, then marriage is possible. Like in cases of South India, you will see that there are various families which actually allow marriage between the maternal uncle and the niece. So it is possible, but yes, it is again depending upon that the custom and usage which governs the parties. So if any question comes with respect to the marriage or validity of the marriage and what are the conditions, and it is related to the degrees of prohibited relationship, you have to check two things. First, that the parties are not falling under this degree of prohibited relationship, and secondly, even if they are falling, there is some backing of their customer uses which governs each of these parties and permits such marriage. Now coming to the next part, because custom and uses plays very important role in cases of sapinda, in cases of degrees of prohibited relationship. So it is very important to know that what the custom and usages are. Can every custom or usage will come under this definition? So it is defined under section 3A of the Hindu Marriage Act 1955. The expressions custom and usage signify any rule which having been continuously and uniformly observed for a long time. So it should be continuous, it should be uniform, and it should be observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group, or family, provided that the rule is certain and not unreasonable or opposed to public policy, and provided further that in the case of a rule applicable only to a family, it has not been discontinued by the family. So, custom and uses may vary from family to family as well, but you have to just check that it is continuous, it is uniform, it is practiced for a very long time, and it has obtained the force of law. It is certain and it is not unreasonable or opposed to public policy. And also you have to see that it is applicable in that family and it is not been discontinued by that family. So these are the tests related to custom and uses. Coming to section 5, subclause 5, which talks about sapindas. So we have seen in the conditions of for a valid Hindu marriage, it talks about sapindas. It provides that the parties are not sapindas of each other unless the custom or uses governing each of them permits of a marriage between the two. Section 3F1. It defines sapinda relationship with reference to any person extends as far as the third generation, inclusive in the line of ascent through the mother, and the fifth, inclusive in the line of ascent through the father, the line being traced upward in each case from the person concerned who is to be counted as the first generation. So, if suppose you have to count it from a person, you have to check that this person is in the first degree, and then you have to see the three generations from the side of mother and five generations from the side of father, and they will fall under the sapinda relationship. Two persons are said to be sapindas of each other if one is a lineal ascendant of the other within the limits of sapinda relationship, or if they have a common lineal ascendant who is within the limits of sapinda relationship with reference to each of them. Coming to the next kind of marriage, that is void marriage. Any marriage solemnized after the commencement of this act shall be null and void, and may, on a petition presented by either party against the other party, be so declared by a decree of nullity if it contravenes any one of the conditions which is specified under clause 1, 4, and 5 of section 5. And just now we have discussed about section 5, which deals with the conditions for a valid Hindu marriage. The first clause, it talks about a spouse living. Suppose the spouse is alive and there is no divorce, then in such cases, in the presence of the spouse, the person cannot marry again. If marries, then it will fall under the provision of bigamy, and we will discuss that in the latter part of this presentation. Section 5, clause number 4 says degrees of prohibited relationship, and clause number 5 says sapindas. So if any of these three, it hits by any of these three, then it will be treated as void marriage. Section 12 talks about voidable marriages. Now, voidable marriages are voidable. From the name itself, you could speculate that it is neither valid nor void, but it is somewhere in between, which may be declared as a valid marriage or as a void marriage. Now coming to what voidable marriages are. Any marriage solemnized shall be voidable and may be annulled by a decree of nullity on any of the following grounds, namely, first is that the marriage has not been consummated owing to the importance of the respondent. So here, consummation of marriage means the physical relationship post-marriage of between the husband and the wife. So if the marriage has not been consummated, means there is no physical relationship established between the parties because of the importance of the party, in that case it will become voidable marriage. And if the party wants, they can go under this provision and make their marriage as a void marriage to be declared it as. Second condition is that the marriage is in contravention of the condition specified in clause 2. Clause 2 we have already discussed that it is related to the consent part. Third number clause says that the consent of the petitioner or where the consent of the guardian in marriage of the petitioner, the consent of such guardian was obtained by force or by fraud as to the nature of the ceremony or as to any material fact or circumstances concerning the respondent. So here we have also seen that it talks about the force and fraud. If the consent is taken by force or fraud, then it again falls under the voidable marriages. Then under clause D it says the respondent was at the time of the marriage pregnant by some person other than the petitioner. So suppose if the wife is pregnant and husband is not the father of this child, this will also such marriage under the ambit of voidable marriages. So when we talk about the pregnancy of the wife, here the interesting thing is that the person should not be aware, means the husband, if suppose the husband is aware about the pregnancy before the marriage, in that case he cannot claim to annul such marriage on this ground. But if suppose the person is ignorant and it has been not informed to him about the pregnancy of the wife, then in that case definitely this provision will help such husband in such cases. Coming to the next provision, no petition for annulling a marriage shall be entertained if the petition is presented more than 1 year after the force has ceased to operate or as the case may be, the fraud has been discovered. So we have seen that it talks about force and fraud if the consent has been taken under section 12. But the petition is presented more than 1 year after the force has ceased or the fraud has been discovered. In that case, no petition for annulling a marriage shall be entertained by the court. The petitioner has, with his or her full consent, lived with the other party to the marriage as husband or wife after the force has ceased to operate, or as the case may be, the fraud has been discovered. So, if she is living and either the husband or the wife, both of them, suppose the consent was taken through fraud or through force, but still they are staying together, they are residing together, then in that case also, after the expiry of this period, no petition for annulling a marriage shall be entertained. Next is no petition for annulling a marriage shall be entertained unless the court is satisfied and it is about the pregnancy. As we have seen that if the wife is pregnant but not by the husband, in that case the petitioner was at the time of the marriage ignorant of the fact alleged. If he is ignorant, definitely the court will take note of the same. But if suppose the petitioner, means the husband here, is aware about the pregnancy, in that case the court will not come to the rescue because it is your ignorance, and if through ignorance you have indulged into such marriage, became a party to such marriage, definitely you will get the benefit of this section. However, in other cases it is not possible if you are not ignorant. Second is that proceedings has been instituted in the case of a marriage solemnized before the commencement of this act within 1 year of such commencement, and in the case of marriages solemnized after such commencement within 1 year from the date of the marriage. So this 1 year time frame is also given, and these are the limitation periods. Means after that the court is not going to entertain any such cases, any such petitions. That marital intercourse with the consent of the petitioner has not taken place since the discovery by the petitioner of the existence of the said ground. So, After knowing the fact that the wife is pregnant by another person, the marital intercourse, the sexual intercourse has come to an end, and there is, with the consent of the party, has not taken place. So, in these cases also, the court has to be satisfied that if the person is allowed to get the benefit of this section or not. So it is up to the satisfaction of the court, and the party who is claiming has to satisfy the court. Otherwise, no petition for annulling a marriage shall be entertained by the court in such scenario. Coming to section 7, it is very interesting. It talks about ceremonies for a Hindu marriage. Now the question arises that is Hindu marriage a contract or a sacrament? So when we talk about contract, definitely Hindu marriage is a kind of sacrament and not purely a contract. However, now it talks about under the provision of divorce, section 13 of the Hindu Marriage Act, the marriage can also come to an end through divorce. So there is some features of contract also here, and even in cases of marriage, the consent is important, and marriage may also come to an end. So these things are some provisions which are related to contract. However, sacrament is also there because it also talks about certain rites and ceremonies, including the saptapadi, which are very important to make the marriage complete. So, section 7 actually talks about the ceremonies for a Hindu marriage. So, by this uh, provision, you can say that Hindu marriages is not purely a contract or nor neither purely a contract nor purely a sacrament, but an admixture of both. So some features of contract, some features of sacrament is present in cases of a Hindu marriage. Section 7 talks about the ceremonies. So a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. Second is where such rites and ceremonies include the saptapadi, that is the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire. The marriage becomes complete and binding when the 7th step is taken. So ceremonies also are very important in Hindu marriage. Section 8 talks about registration of Hindu marriage. If you read this provision, you will find that it says the state government may make rules. So when it says may make rules, it means that it is discretionary. If the term was shall, if it could have been used in the provision, it could have been made mandatory. But the term is may. So the state government may make rules providing that the parties to any such marriage may have the particulars relating to their marriage entered in such manner and subject to such conditions as may be prescribed in a Hindu marriage register kept for this purpose. So, registration of marriage is neither mandatory nor optional, but it depends upon the state government and whatever rules they have made in this regard. So, in some states, it is mandatory to register the marriage. However, in some states, it is not mandatory but only optional in those states. So it is again depending upon the state and the state government that what rules they have made in this regard. And secondly, the rules may vary from state to state. Say for example, in Maharashtra, registration of Hindu marriage is mandatory. However, in West Bengal, it is not mandatory but optional, but it has not posed any kind of difference in the validity of the marriage. So, if all the rituals and the conditions are fulfilled, which we have just discussed under section 5 of the Hindu Marriage Act 1955, then the marriage is valid, irrespective of the fact that it has been registered or not. You just have to check that in which state this marriage has taken place and what the rules related to registration of marriage is made by the state government, concerned state government. Coming to the 270th report of the Law Commission of India on compulsory registration of marriage 2017. Now I'm just quoting the Law Commission of India from its 270th report. It said that since independence, numerous initiatives have been taken to address the issue of gender inequality. Reform initiatives taken so far as it have succeeded to a large extent. However, child marriages, bigamy, and gender violence continue to persist in our society despite legislation prohibiting and penalizing such practices. Several disputes are pending before the court regarding matrimonial status of the parties. Women are often denied the status of wife due to absence of records providing a valid marriage. The courts have time and again emphasized on making registration of marriage compulsory to prevent denial of status to human women and to children born out of wedlock. Instances of marriage fraud have also come to light in recent times. The Law Commission of India in this report further said that the Registration of Births and Deaths Act be amended to include marriages. It would provide citizens not new rights but better enforcement of existing rights under the various family laws that grant and provide to protect many rights of spouses within a marriage. I have highlighted Sikh law here because Sikh is a religion which is included within the definition of Hindu. However, related to marriage, they have also one special legislation. So there has been a long-standing demand for registering marriages under the Anand Marriage Act of 1909 for Sikh couples who do not wish to use the provisions of Hindu Marriage Act 1955. So they have this alternative available. This was enabled in a limited way by the government of Delhi, and Sikh marriages can now be registered under this Act of 1909 instead of the Act 1955. Coming to section number 9, that is restitution of conjugal rights. First, let us discuss that what restitution of conjugal rights means. When either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. The explanation says where a question arises whether there has been reasonable excuse for withdrawal from the society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society. So here in these cases, you have to be very careful that whether the excuse which has been taken by the party is reasonable or not. Suppose, let me give you one example here. Suppose the wife is working and the parties their matrimonial home is suppose in Kolkata and wife is working in Chennai. Now here for her work, she has to leave Kolkata and she has to go there for her career. She has to go to Chennai. Now in these cases, if the husband says that she has to leave her job and be with me, this is not something which is reasonable. However, the wife, if she says that no, it is not possible for me to come right away because I have a career, I have a job there, in such cases, it will be taken as a reasonable excuse. So you have to be very careful, and it will be vary from situation to situation depending upon what excuse the parties are taking and whether that excuse is a reasonable excuse or not. Section 10 talks about judicial separation. Either party to a marriage may present a petition praying for a decree for judicial separation on any of the grounds specified in subsection 1 of section 13, and in the case of a wife, also on any of the grounds specified in subsection 2 thereof as grounds on which a petition for divorce might have been presented. Interestingly, when we talk about judicial separation and divorce, the grounds are similar. So, which is provided under section 13, subsection 1 and 2, which is provided under clause 1 of section 10. Now, if you go by subsection 2, it says where a decree for judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court may, on the application by petition of either party and on being satisfied of the truth of the statements made in such petition, resign the decree if it considers it just and reasonable to do so. So when we talk about judicial separation and divorce, as mentioned earlier, that the grounds are same and grounds are provided under section 13, which talks about divorce. But there is a difference between judicial separation and divorce. In cases of judicial separation, the relationship between the parties is not coming to an end. They are still treated as husband and wife, even though they are residing separately. However, the moment divorce is final and binding on the parties, then both the parties can start a new life with another person. However, in case of judicial separation, it is not possible. So, the marriage is still subsisting in case of judicial separation, but in cases of divorce, the marriage comes to an end. So, this is the distinction between judicial separation and divorce. However, the grounds, as I mentioned, is same and provided under Section 13 of this Act. Coming to Section 13, what are the grounds for divorce? Any marriage solemnized may, on a petition presented by either the husband or the party, be dissolved by a decree of divorce on the ground that the other party has, after the solemnization of the marriage, had voluntary sexual intercourse with any person other than his or her spouse. 1A says has, after the solemnization of the marriage, treated the petitioner with cruelty, or 1B says has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petition. So let us just break this sub clause 1. It talks about the voluntary sexual intercourse other than the spouse. Means it actually talks about adultery, sex outside marriage with another person who is not your spouse. Now, in such cases, the provision is of adultery. Previously, adultery was also a punishable offense, but now, recently, it has been omitted, and now adultery is no more a punishable offense, but it is still existing as a ground for divorce in the personal laws. Next is cruelty and desertion, which is also the grounds for divorce. Subsection 1, clause 2 says, has ceases to be a Hindu by conversion to another religion. So, this is again a valid ground for divorce. The marriage should not uh, come to an end automatically by conversion, but definitely it gives a valid ground for divorce if a person converts to another religion. Subsection 3 says has been incurably of unsound mind or has been suffering continuously or intermittently from medical disorder or such of such a kind and to such an extent that the petitioner cannot reasonably be expected to live with the respondent, has been suffering from venereal diseases in a communicable form, or has renounced the world by entering into any religious order, or has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of it had that party been alive. Now, this 7 years is legally a person is seen as dead if for 7 years the person is not being heard of alive. So in such cases, also this is a ground for filing a petition for divorce by the parties. Section 30, subsection 2 says a wife may also present a petition for divorce on the ground. So section 13, subsection 1 is given, which it provides is for both husband and wife. However, section 13, subsection 2 is exclusively designed for wife, and wife is getting additional provision under section 13 subsection 2 additional grounds to present a petition for divorce. The first ground is in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of the husband married before such commencement was alive at the time of the solemnization of the marriage of the petitioner, provided that in either case the other wife is alive at the time of the presentation of the petition, or that the husband has, since the solemnization of the marriage, been guilty of rape, sodomy, or bestiality. Section 13, subsection 2 again provides the additional grounds. Under clause 3, it says that in a suit under section 18 of the Hindu Adoption and Maintenance Act 1956, or in a proceeding under section 125 of the Code of Criminal Procedure, or under the corresponding section 488 of CRPC, that is Code of Criminal Procedure, A decree or order, as the case may be, has been passed against the husband, awarding maintenance to the wife, notwithstanding that she was living apart, and that since the passing of such decree or order, cohabitation between the parties has not been resumed for 1 year or upwards. So this also gives right to divorce the spouse, that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she has repudiated the marriage after attaining the age but before attaining the age of 18 years. So this provision is actually related to the child marriages part. Now, Justice Verma Committee report also talked about marital rape, and here I have highlighted this because there can be marriage which is a child marriage where the girl is below the age of 15 or below the age of 18. So, in such a circumstance, the Justice Verma Committee report, which came just after the Nirbhaya gang rape case, and this report was historic because on the basis of this, the Criminal Law Amendment Act has taken place. So many changes in the Indian Penal Code was done. It was amended after the Justice Verma Committee report. So there is one segment where it has talked about marital rape. In India, we don't recognize marital rape. However, there is one case law which we'll discuss where below the age of 18 years, it has been to some extent the protection has been granted to the wife. However, it is if the wife is above the age of 18, in that case, this security, this protection is not provided because marital rape is not considered as a rape in our Indian legislation in criminal law. So the exemption of for marital rape it stems from a long outdated notion of marriage which regarded wives as no more than the property of their husbands. According to the common law of coverture, a wife was deemed to have consented at the time of the marriage to have intercourse with her husband at his whim. Moreover, this consent should not be revoked. The Verma Committee also recommended that the exception for marital rape should be removed from the provision of rape. The law ought to specify that a marital or other relationship between the perpetrator or victim is not a valid defense against the crime of rape or sexual violation. So, marriage does not give you a license to rape. The relationship between the accused and the complainant is not relevant to the inquiry into whether the complainant consented to the sexual activity. The fact that the accused and victim are married or in another intimate relationship may not be regarded as a mitigating factor justifying lower sentences for rape. So as I was discussing, this case is landmark case, that is Independent Thought versus Union of India. This case came in the year 2017 where the Honorable Supreme Court of India read down exception 2 of section 375, which was the provision of rape in Indian Penal Code, that allowed the husband of a girl child between 15 and 18 years of age the right to have intercourse with her. It was the previous provision. After this case came, the Supreme Court dealt specifically with the exception dealing with married girls aged between 15 to 18. The court rightly held that a child remains a child regardless of whether she is married or she is unmarried, and therefore intercourse with a minor would be rape regardless of her marital status. So till the age of 18, now even after even if there is a child marriage, the girl is protected, the wife is protected from sexual intercourse. However, the moment she crosses the age of 18, in that case, the consent is deemed to be that she has given her consent at the time of marriage and it is not going to be revoked, and that's why the husband, as per his whims, anytime he can have sexual intercourse with the wife, it will not fall under the provision of rape, so not punishable. Now, recently the penal legislation has been renamed and it has revamped as Bharatiya Nyaya Sanhita. So previously it was Indian Penal Code and section 375 was there related to rape. Now in Bharatiya Nyaya Sanhita, there is section number 63 which provides the provision related to rape. Interestingly, exception 2 of section 63 provides sexual intercourse or sexual act by a man with his own wife, the wife not being under 18 years of age, is not rape. So here the relationship is being taken into consideration. The consent of wife is not taken if she is above the age of 18 years. This means if a married woman is above 18, then Through marriage, the husband gets the license to rape the wife as it is exempted from the provision of rape under section 63, exception 2 of the Bharatiya Nyaya Sanhita. Section 13A talks about alternative relief in divorce proceedings. It's very interesting that suppose if the petition is filed for divorce, but there are these three grounds which are present, like has ceases to be a Hindu by conversion, or has renounced the world by entering any religious order, or has not been heard of as being alive for a period of 7 years or more. So, in such cases, on a petition for dissolution of marriage by a decree of divorce, the court may, if the court finds it just so to do, having regard to the circumstances of the case, because each case has its own story and they vary from case to case basis, it passed instead a decree of judicial separation, except insofar as the petition is founded on the grounds mentioned in clause 13, subsection 1, 2, that is, has ceases to be a Hindu by conversion, or has renounced the world by entering any other religious order, or has been heard of as being alive for a period of 7 years or more. So, if these are the conditions, in that case, divorce will be granted. But if it is not there, except these grounds, if any other ground is there, which is there under section 13, in that case, alternate relief can also be provided. So, even if the petition is for dissolution of marriage or for divorce, the court, if deems fit that it will pass a decree of judicial separation, the court may pass. Okay. Now coming to section 13B, which talks about divorce by mutual consent. Now, a petition for dissolution of marriage by a decree of divorce may be presented to the district court by both the parties to a marriage together on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and that they have mutually agreed that the marriage should be dissolved on the motion of both the parties, made not earlier than 6 months, and the 6 months is the cooling period after the date of presentation of the petition, and not later than the 18 months after the said date. If the petition is not withdrawn in the meantime, the court shall, on being satisfied after the hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized and that the averments in the petition are true, it may pass a decree of divorce declaring the marriage to be dissolved with effect from the date of the decree. Coming to irretrievable breakdown of marriage. Irretrievable breakdown of marriage means a marriage beyond repair. Irretrievable breakdown of marriage refers to a situation where the marital relationship has deteriorated beyond repair, meaning there is no reasonable hope of reconciliation or continuation of the marriage. While not a specific ground for divorce, under all laws it is recognized by courts in India, particularly by the Honorable Supreme Court, which can grant divorce in such cases overriding statutory limitations through Article 142 of the Constitution. The Law Commission of India, in its 71st and 217th report, also recommended regarding irretrievable breakdown of marriage to be included as a ground for divorce, but yet it is not there in the law book. However, as I said, that Supreme Court may, in many cases, it can use this under Article 142 of the Constitution. Section 14 talks about no petition for divorce to be presented within 1 year of marriage. Now, this is actually a period which is provided 1 year time where the marriage cannot be dissolved, or court shall not entertain any petition related to dissolution of marriage, related to divorce, unless at the date of the presentation of the petition 1 year has elapsed since the date of the marriage. So, if the marriage has crossed 1 year's time, then the court will entertain, otherwise it shall not, provided that the court may allow a petition to be presented before 1 year has elapsed since the date of the marriage on the ground that the case is one of exceptional hardship to the petitioner or of exceptional depravity on the part of the respondent. So, in exceptional case only it may be allowed by the court. In disposing of any application, the court shall have regard to the interests of any children of the marriage and to the question whether there is a reasonable probability of a reconciliation between the parties before the expiration of the said 1 year. Section 15 talks about divorced persons when we marry again. After divorce, when a person can get married. So, when a marriage has been dissolved by the decree of the divorce and either there is no right of appeal against the decree, or if there is such a right of appeal but the time of appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed. It shall be lawful for either party to the marriage to marry again. So once you are getting the decree of divorce, it does not mean that immediately the party may marry. The party has to wait till the decree gets finality, and it will get after the appeal period is lapsed. Or if suppose during the appeal period it has been filed before the court, but it has been dismissed by the court. So these are certain conditions after which the divorced person can marry again. Section 16 talks about legitimacy of children of void and voidable marriage. A marriage is null and void under Section 11. Any child of such void marriage who would have been legitimate if the marriage has been valid shall be legitimate. Where a decree of nullity is granted in respect of a voidable marriage under Section 12, any child begotten or conceived before the decree is made who would have been the legitimate child of the parties to the marriage shall be deemed to be their legitimate child. So, under Section 11 and 12, which we just discussed about the void marriage and voidable marriages, suppose during that time when the marriage was continuing, there is a child conceived, and this child will be treated as a legitimate child, means the child will get property rights. But there are certain limitations, there are certain rules because the marriage is not valid. It is void or voidable marriage. In case of valid marriage, the child gets all the rights related to property and all other rights. But when we talk about void and voidable marriages, there are certain differences. In cases of the child is legitimate, but the rights of the child may be different. So, any child of a marriage which is null or void or which is annulled by a decree of nullity under Section 12, any right in or to the property of any person other than the parent, such child would have been incapable of possessing or acquiring any such right by reason of his not being the legitimate child of his parent. Recommendation by the Law Commission of India in its consultation paper on reform of family law 2018. This report said that Section 16 should be amended to include all children born out of wedlock and not just those from void and voidable marriages. Further, the term illegitimate should not be used in any statute or document because when we are using this term illegitimate child, we are accusing the child that the child is illegitimate. However, it is the fault of the parties. So, the child should never be treated as illegitimate child. Section 17 talks about punishment of bigamy. Any marriage between two Hindus solemnized after the commencement of this act is void if at the date of such marriage either party has a husband or wife living, and the provisions of Section 494 and 495, that was the previously Indian Penal Code 1860, shall apply accordingly. Now, after the BNS is there, BNS also has tried to club these two sections, that is section number 494 and 495 from the Indian Penal Code, and it has clubbed it together into one section laid down under section 82 of the Bharatiya Nyaya Sanhita or BNS, which provides marrying again during the lifetime of the husband or wife. Section 18 talks about punishment for contravention of certain other conditions for a Hindu marriage. Every person who procures a marriage of himself or herself to be solemnized under this act is in contravention of the conditions specified in clauses 3, 4 and 5 of section 5 shall be punishable in the case of contravention of the condition specified in clause number 3 of section 5 with rigorous imprisonment which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both in case it is in contravention to clause number 4 and 5 with simple imprisonment which may extend to 1 month or with fine which may extend to 1000 rupees or with both. Section 19 talks about court to which the petition shall be presented. So, every petition under this act shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction. First, the marriage was solemnized, or the respondent at the time of the presentation of the petition resides, or the parties to the marriage last resided together, or in cases the wife is the petitioner where she is residing on the date of presentation of the petition, or the petitioner is residing at the time of the presentation of the petition in a case where the respondent is at the time residing outside the territories of which this act extends or has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of him if he was alive. Section 21B talks about special provisions relating to trial and disposal of petitions under the Act. The trial of a petition under this Act shall, so far as it practicable consistently with the interest of justice in respect to the trial be continued from day to day until its conclusion unless the court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded. Every petition under this act shall be tried as expeditiously as possible, and endeavours shall be made to conclude the trial within 6 months from the date of service of notice of the petition on the respondent. Every appeal under this act shall be heard as expeditiously as possible, and endeavour shall be made to conclude the hearing within 3 months from the date of service of notice of appeal on the respondent. Section 21C talks about documentary evidence. No document shall be inadmissible in evidence in any proceeding at the trial of a petition under this Act on the ground that it is not duly stamped or registered. Previously, the Evidence Act was applicable. Now, the Bharatiya Sakya Adhiniyam will be applicable in such cases related to evidence. Section 22 talks about proceedings to be in camera and may not be printed or published. Every proceeding under this Act shall be conducted in camera, and it shall not be lawful for any person to print or publish any matter in relation to any such proceeding except a judgment of the High Court or of the Supreme Court printed or published with the previous permission of the court. Second is if any person prints or publishes any matter in contravention of the provisions contained in subsection 1, he shall be punishable with fine which may extend to 1000 rupees. Section 23A talks about relief for respondent in divorce and other proceedings. In any proceeding for divorce or judicial separation or restitution of conjugal rights, the respondent may not only oppose the relief sought on the ground of petitioner's adultery, cruelty, or desertion, but also make a counterclaim for any relief under this Act on that ground. And if the petitioner's adultery, cruelty, or desertion is proved, the court may give to the respondent any relief under this Act to which he or she would have been entitled if he or she had presented a petition seeking such relief on that ground. Section 24 talks about maintenance, pendency light, and expenses of proceedings. Pendency light, this means that during the pendency of the case, where in any proceeding under this Act, it appears to the court that either the wife or the husband, so this is a gender neutral provision because it gives maintenance to both wife and husband, has no independent income sufficient for her or his support and the necessary expenses of the proceeding, it may, on the application of the wife or the husband, order the respondent to pay to the petitioner the expenses of the proceeding and monthly during the proceeding, such sum as having regard to the petitioner's own income and the income of the respondent, it may seem to the court to be reasonable, provided application for the payment of the expenses of the proceeding and such monthly sum during the proceeding shall as far as possible be disposed of within 60 days from the date of service of notice on the wife or the husband as the case may be. Section 25 talks about permanent alimony and maintenance. Any court exercising jurisdiction under this Act may at the time of passing any decree or at any time subsequent thereto on application made to it for the purpose of by either the husband or the wife, as the case may be, order that the respondent shall pay to the applicant for her or his maintenance and support such gross sum or such monthly or periodical sum for a term not exceeding the life of the applicant as having regard to the respondent's own income and other property, if any, the income and other property of the applicant, the conduct of the parties and other circumstances of the case, it may seem to be court to be just, and any such payment may be secured, if necessary, by a charge on the immovable property of the respondent. It further says that if the court is satisfied that there is a change in the circumstances of either party at any time after it has made an order, it may, at the instance of either party, vary, modify, or resign any such order in such manner as the court may deem fit. If the court is satisfied that the party in whose favor an order has been made under this section has remarried, or if such party is the wife, that she has not remained chaste, or if such party is the husband, that he has had sexual intercourse with any woman outside wedlock, it may at the instance of the other party vary, modify, or resign any such order in such manner as the court may deem fit. Section 26 talks about custody of children. In any proceeding under this Act, the court may from time to time pass such interim orders and make such provisions in the decree as it may deem just and proper with respect to the custody, maintenance, and education of minor children, consistently with their wishes, wherever possible, and may, after the decree, upon application by petition for the purposes, make from time to time all such orders and provisions with respect to the custody, maintenance, and education of such children as might have been made by such decree or interim order in case the proceeding for obtaining such decree were still pending, and the court may also from time to time revoke, suspend, or vary any such orders and provisions previously made, provided that the application with respect to the maintenance and education of the minor children pending the proceeding for obtaining such decree shall, as far as possible, be disposed of within 60 days from the date of service of notice on the respondent. Section 27 talks about disposal of property. In any proceeding under this Act, the court may make such provisions in the decree as it deems just and proper with respect to any property presented at or about the time of marriage which may belong jointly to both the husband and the wife. Section 28 talks about appeals from decrees and orders. All decrees made by the court in any proceeding under this Act shall be appealable as decrees of the court made in the exercise of its original civil jurisdiction, and every such appeal shall lie to the court to which appeals ordinarily lie from the decisions of the court given in the exercise of its original civil jurisdiction. Orders made by the court in any proceeding under this Act shall be appealable if they are not interim orders, and every such appeal shall lie to the court to which appeals ordinarily lie from the decision of the court given in exercise of its original civil jurisdiction. There shall be no appeal under this section on the subject of costs only. Every appeal under this section shall be preferred within a period of 90 days from the date of the decree or order. Section 28A talks about enforcement of decrees and orders. All decrees and orders made by the court in any proceeding under this Act shall be enforced in the like manner as the decrees and orders of the court made in the exercise of its original civil jurisdiction. Section 29 talks about the savings, and it is actually a very interesting and important provision of this Act because prior to the 1955 Act, that is the Hindu Marriage Act of 1955, even in Hindus there were more than one marriages. But after this Act came to being, a Hindu can only marry once during the lifetime of the spouse, or suppose after giving divorce only the person can marry again, which we have discussed in the preceding section. So section 29 actually is the saving clause. It says a marriage solemnized between Hindus before the commencement of this Act, which is otherwise valid, shall not be deemed to be invalid, or even to have been invalid by reason only of the fact that the parties thereto belong to the same gotra or pravara, or belong to different religions, caste, or subdivisions of the same caste. Nothing contained in this Act shall be deemed to affect any right recognized by custom or conferred by any special enactment to obtain the dissolution of a Hindu marriage, whether solemnized before or after the commencement of this Act. Nothing contained in this Act shall affect any proceeding under any law for the time being in force for declaring any marriage to be null and void, or for annulling or dissolving any marriage, or for judicial separation pending at the commencement of this Act, and any such proceeding may be continued and determined as if this Act has not been passed. Nothing contained in this Act shall be deemed to affect the provisions contained in the Special Marriage Act 1954 with respect to marriages between Hindus solemnized under the Act, whether before or after the commencement of this Act, means the Act of 1955. Now, in conclusion, I just say that the Hindu Marriage Act provides marriage and divorce related provisions exclusively for Hindus. Various reports have suggested certain changes in the Act, and I also think that these changes will definitely help this legislation more useful for the Hindus in future. Coming to few questions. Question number 1 says, how many types of marriages are there under the Hindu Marriage Act of 1955? First option is 2 types, valid and void marriage. Second is 3 types, valid, void and voidable marriage. Third is 4 types, valid, void, voidable and child marriages. D is none. So the correct answer here is B, that is 3 types, valid, void and voidable marriages.